Hello and welcome. This is part 2 of the Memorandum in support of petition for Writ of Habeas Corpus under 28 U.S.C. subsection 2241. We were toward the end of page 7 in part 1, and we concluded around this paragraph right here in the quote, failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order, end quote. And it continues. On June 28, 2024, the jury sent the following note to the court, quote, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict, end quote. June 28, 2024, the court asked counsel for their views, quote, on whether there had been due and thorough deliberations, end quote, sufficient to support the giving of a so-called Tui Rodriguez charge. And they are citing a citation. They're citing an attachment as well as a case law. Continuing. The Commonwealth responded that the charge should not be given because there, quote, simply hadn't been sufficient time yet, end quote, June 28, 2024. Counsel for Ms. Reed disagreed, requesting that the court, quote, read the Tui Rodriguez model instruction and go from there, end quote. The trial court sided with the Commonwealth, ruling, quote, I am not prepared to find that there have been due and thorough deliberations at this point, so I am going to send them back out, end quote. On July 1st, 2024, the jury presented another note stating, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. If you remember my previous videos, I have commented extensively about the intelligence and the intellect of this jury foreman. He was not an idiot. He clearly could write a complete sentence, and not just a complete sentence, but an eloquently written sentence, right? But he somehow was confused that he wasn't supposed to disclose to Judge Bev and to the rest of the world that there were verdicts on counts 1 and 3. And I'm not entirely faulting him because, again, Fanning was involved. Fanning was apparently supervising the jury during the Karen Reed trial. Fanning being one of the pawns in Michael Morrissey's scheme in this entire cover-up. Fanning having an extensive history and reputation of being an abuser, abusing men and women. Fanning was put in charge of the jury as yet another major conflict of interest in the Karen Reed case. Michael Morrissey had such audacity and arrogance and maliciousness to appoint Fanning to supervise the jury members. So I'm saying, as frustrated as we have all been with this particular jury foreman, And another point to that, guys, before I continue my point, a lot of people are surprised that Judge Bev was permitted to select the foreman, but in Massachusetts, the judge is permitted to select the foreman. So I'm just saying, could this be the only case in which Judge Bev ruled incorrectly? Could this be the only cover-up under Michael Morrissey's belt? Under Judge Beverly Cannoni's belt? Massachusetts has everything laid out perfectly for corrupt individuals to take on positions of power and fuck over people's lives. The judge can select the foreman in the state of Massachusetts. And if you are a corrupt judge and a corrupt district attorney, it puts everything in your domain to fuck over somebody like Karen Reed. So I give the foreman shit for not understanding that he was supposed to write in the notes that there were verdicts on counts 1 and 3, but I don't put the entire onus on him. I also put the onus on Michael Morrissey at the very top of this corrupt pyramid. So much about this case doesn't make sense, but if you look between the lines and you make the connections, you connect the dots, it all makes sense. It's not that far-fetched, It's, if you are paying attention to the minuscule things as well as the overt things, they all connect, and some of that might lead you to speculative conclusions, but for the most part, the corruption is blatantly obvious. Even an idiot could figure out that the corruption is there. And it's not a mistake that the foreman did not write the verdicts for counts 1 and 3 on any of the jury notes. It's not a mistake. He was too intelligent, too good of a writer to be mistaken about not including the verdicts on counts 1 and 3 in any of the jury notes. More likely, Fanning had him under his thumb. Fanning was reviewing the jury notes before the foreperson submitted those jury notes to the court. And I'm not saying this factually. I am saying it's more likely, especially with the revelations made recently that Fanning was in charge of the jury. And the fact that like Judge Bev, can play dumb or she can play apathetic. The fact is she absolutely had a key role in how this all played out. Michael Morrissey could not have gotten away with the corruption without Judge Beverly Cannoni's help. There's no way. So I'm saying, to all the people who hate on the Karen Reed supporters for giving Judge Beverly Cannoni so much shit, you have to be playing dumb or you have to be looking the other way to not know that Judge Beverly Cannoni is absolutely involved in the corruption. She is absolutely involved in the cover-up. Michael Morrissey could not have done this. It wasn't enough to have Fanning. It wasn't enough to be dictating the notes of the jury. It wasn't enough to have a really good writer as the foreman who could write so eloquently and impress Judge Bev. It had to be Judge Bev at the end. It had to be Judge Bev as yet another safeguard for the prosecution to get what they want. And yes, a mistrial is not what they want ultimately, but a mistrial has allowed the prosecution to go on with motion after motion after motion, with attempt after attempt to completely undo the defense's case, to completely undo the well thought out, well structured defense the attorneys came up with in defense of Karen Read. So I'm saying, guys, like Michael Morrissey must have done this before. The Karen Read case could not possibly be Michael Morrissey's only case in which he corrupted the results, in which he dictated the results from the beginning of trial, from the beginning of the investigation to the beginning of trial, and all the way to the jury deliberations, and then to ultimately the jury verdicts, right? So I am saying, as I've said many times before, people in Norfolk County should be livid, and they should be afraid, because Michael Morrissey still has a whole lot of power there. And there are likely other Karen Reads currently being prosecuted right now, or there are likely other Karen Reads currently incarcerated right now because of Michael Morrissey's corruption. Continuing. July 1st, 2024. Upon being asked by the court, the parties reiterated their same previously expressed views, with the Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Miss Read's counsel arguing that the court should give a Tui Rodriguez instruction. And they cite an attachment. This time, the trial court decided to give the requested instruction. Later that day, the jury sent yet another note. Thereafter, without reading the note to counsel and without providing counsel with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges. And there's a footnote here. It's number 3. It reads, in the SJC's words, quote, the Tui Rodriguez charge is a model instruction given when jurors report a deadlock after due and thorough deliberation that is designated to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. End quote. And again, guys, even the SJC agrees with Judge Bev that the Tui Rodriguez instruction is an alternative to a mistrial, when in fact, in their own wording, the SJC describes the Tui Rodriguez charge as an instruction, and then as an urge, designed to urge. The SJC agrees with Judge Bev that the Tui Rodriguez is an alternative to declaring a mistrial, but in the way the SJC describes a Tui Rodriguez charge, they refer to it as an instruction, and that is designed to urge the jury to reach a verdict. Yep, just a bunch of judges sitting up there in high places in Massachusetts who agree with one another, even though by agreeing with one another, they prove how incorrect and ill-informed they are as judges. Yep. I will read the few words here to lead into the next sentence. The implication of a potential mistrial on one or more charges. The trial court simply stated, quote, the jury is at an impasse, end quote, and immediately called in the jurors. It then read the note on the record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. After reading the note and without soliciting the views of counsel in any respect, the trial court stated, quote, "I am not going to do that to you folks. Your service is complete. I am declaring a mistrial in this case," end quote. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this entire interaction. And if you haven't seen my SJC videos, I provided commentary about that last note. The jury note, the third one, the last one, right before Judge Bev declared the mistrial. That note, to me, the third jury note right here, despite our rigorous efforts, to me, this note was written this way on purpose so that any other judge looking back on the record would look at this note, and this note would represent a standard summary of what would happen when a jury are hung. You know? So convenient that the third note in the Karen Reed case, the third jury note, is written in a way to describe to onlookers what a hung jury looks like. It's a description of a hung jury. At face value, someone looking at it at face value, just surface level understanding, it looks like the jury is hung. It reads as if the jury is genuinely hung. You know, our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Right? Like, is that true? Did that really happen? Or is that just a summary that the foreman was told to give the court so that it could be documented on the court record? And then this sentence, conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. You know, like it looks like, again, surface level, face value, it looks like a hung jury. It looks like a description of a hung jury, so that any other judges looking back on this case, like an appellate court looking back on this case, looking at it at face value and not conducting their own investigation of what really happened during trial or what really happened to the jury or whether Fanning was actually supervising them or whether the results were being dictated by Michael Morrissey at the top or whether Judge Bev was dictating to the foreman what he could or could not write on those jury notes, or the fact that Judge Bev didn't even rely on Rule 27B in order to make the ambiguous jury notes more clear, like, I don't know, providing the verdicts of counts 1 and 3, right? The last jury note was written the way it was written to me so that any future judge looking back on this case and reading the jury note would assume that the jury members were genuinely hung, when in fact they were not. When in fact there were verdicts and the foreman failed to communicate those verdicts to the judge. And on top of that, as an additional safeguard, Judge Bev failed to rely on Rule 27B, which would have informed the world that Karen Reed was found not guilty of counts 1 and 3. And she was actually found not guilty of count 2, but they were stuck on 2 because of the lesser included offenses. The lesser included charges, like the one that involves her BAC level, which again, the prosecution, the investigators likely lied about. They've lied about everything else. So I'm just saying, guys, I'm leaving this on the screen so that you guys can read it yourselves. This is what an inside job looks like. And all those safeguards I talked about in part 1. The foreman must have been instructed to write the note like this, so that it's covering Judge Bev's ass, it's covering the prosecution's ass, and the person who is victimized the most because of the ambiguity of the jury note, because of the narrative in the jury note, is Karen Reed. The last jury note that was given to Judge Bev before she declared a mistrial is a narrative. It is the narrative the prosecution wanted. It is the narrative that Michael Morrissey wanted, as they realized that the results were not going to be in the prosecution's favor. As they realized that despite all of their efforts, the jury members agreed on counts 1 and 3. Continuing. The following day, on July 2, 2024, unsolicited by any party, one of the jurors, in parentheses, quote, Juror A, end quote, contacted one of the attorneys for Miss Reed, Alan Jackson. Juror A stated that he, quote, wished to inform Attorney Jackson of the true results, end quote, of the jury's deliberations. Affidavit of Alan J. Jackson is attached. According to Juror A, quote, the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder was, quote, off the table, end quote, and that all 12 of the jurors were in agreement that she was not guilty of such crime, end quote. And they cite the attachment, quote, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury/death, end quote. I'm going to read this footnote back on page 9. Footnote number 4, it reads, for purposes of adjudicating Miss Reed's double jeopardy claim, both the trial court and the SJC, quote, accepted, end quote, the jury statements reflected in the post-trial affidavits, quote, as true and accurate, end quote. Remember that, guys? I'm really glad I read that footnote because I had actually forgotten about this detail. There's so much to remember, guys, in the Karen Reed case. There's so much to remember. Thank goodness that the detail is right here. True and accurate. Remember that, guys? In Judge Beverly Cannoni's denial of Karen Reed's motion to dismiss, when Judge Beverly Cannoni denied the motion, in her denial, Judge Bev informed the world that she believed the jury members. Remember that? Remember that, guys? Judge Beverly Cannoni believed the affidavits. She believed the jury members. She acknowledged that their verdicts on counts 1 and 3 were true and accurate. But because it was after the fact, and because those verdicts were not announced in open court, again, this is Judge Beverly Cannoni's reasoning, because those verdicts were not announced in open court, Judge Bev wasn't going to do a damn thing with those verdicts. It's like in your face kind of corruption. It's like, yeah, we're corrupt and it's in your face. And what are you going to do about it? That's the level of corruption in the Karen Read case. That Judge Beverly Cannoni will acknowledge the statements, the affidavits submitted by the jurors and submitted by the attorneys on behalf of the jurors, and that even the prosecution will acknowledge that the jury members reached out to the prosecution in addition to reaching out to the defense team. That Judge Beverly Cannoni and the prosecution will acknowledge those jury members, and they will acknowledge the jury members' efforts and attempts to clarify the record. But both the prosecution objects to hearing the jury members, and Judge Beverly Cannoni objects to hearing the jury members. Judge Beverly Cannoni treated those jury members like they were her children during the trial. She treated them as if she was like a kindergarten teacher and they were her students. But when it came to doing the right thing, Judge Bev is like, fuck those jury members. I don't give a fuck. I don't care if they all agree. I don't care if all 12 of them submit affidavits. I don't give a fuck. I'm not going to do a damn thing with those verdicts because they weren't announced in open court. Again, guys, multiple safeguards for the prosecution when, in fact, there were supposed to be multiple safeguards for the defendant, Karen Read. The corruption in this case is complex. It runs deep, guys. It's multi-layered. There were multiple steps taken during the trial and during deliberations and after trial to ensure that the world would never know that Karen Read was found not guilty of counts 1 and 3. And then to ensure that despite the world being informed that there were verdicts of counts 1 and 3, despite that information coming out, the prosecution and Judge Bev made additional efforts to ensure that the verdicts for counts 1 and 3 would not matter. And they all want to gaslight us. You know, Hank Brennan, he wants to come in late in the game and gaslight us. Gaslight the world with his lies and with his gaslighting. When we all already know, those of us paying attention, we all know that the corruption runs deep. It is so complex. And it's so extensive. It's not just little things. It's not just micro corruption. It is in your face corruption. To the extent that Judge Bev will consider that, in fact, the verdicts on counts 1 and 3, the not guilty verdicts on counts 1 and 3, are true and accurate. But as if to rub it in Karen Reed's face, Judge Bev did not want to do anything about it. She did not want to do anything about those verdicts when it was well within her power to do so, as the amicus brief submitted by the ACLU went into, that in fact, post-trial jury inquiries happen in Massachusetts. They happen. Continuing, we are on page 10. One day later, on July 3rd, 2024, another attorney for Miss Reed, David Yannetti, was contacted by, quote, two different individuals hereinafter, informant B and informant C, who had received information from two distinct jurors, in parentheses hereinafter, Juror B and Juror C, both of whom were part of the deliberating jury in this case, end quote. Affidavit of David R. Yannetti attached. Informant B sent attorney Yannetti, quote, a screenshot she had received from someone, hereinafter intermediary B, of text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose, end quote. Juror B later placed an unsolicited phone call to attorney Yannetti, confirming that the information contained in the publicly filed affidavit was accurate. See supplemental affidavit of David R. Yannetti attached. Quote, Juror B clarified, however, that she meant to write, no one thought she hit him on purpose or even knew that she had hit him, end quote. Juror B further told attorney Yannetti she, quote, believed that every member of the jury, if asked, would confirm that the jury reached not guilty verdicts on indictments 1 and 3, end quote. Informant C had been in contact with another individual, intermediary C, who is a co-worker and friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. And then it reads, intermediary C, quote, no consideration for murder 2. Manslaughter started polling at 6-6, then ended deadlock at 4 no, 8 yes, end quote. Informant C, quote, interesting, if it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing, end quote. Intermediary C, quote, she should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing, end quote. Yep. As we all know, pulling away from the memorandum, as we all know, even after Judge Bev revised the jury slip, the jury verdict slip, it was still designed to confuse the jury members. And guys, if you follow enough psychology, I've been following psychology for years, and I recommend that you do. Just look up any psychologist on YouTube. I follow several, and it is insightful information that we should all know so that we are all aware, especially when someone's full of shit. And, confusing people is an abusive tactic. I talked about Hank Brennan having abusive tactics in a previous video. The tactic of confusing people is also an abusive tactic. The fact that the jury slips, the verdict slips, were confusing, and even after they were revised, it was still confusing, and we still didn't learn that Karen Reed was found not guilty of counts 1 and 3 until after the trial ended. Like, that's also an abusive tactic. When you're confused on purpose, you're made to be confused on purpose, then you're not sure what to think. You're not sure about reality. And a lot of us don't assume the worst, especially when we're being guided by authority, when we're being guided by members of authority, people in positions of power, you know? So I'm saying, like, the jury members were confused on purpose. They were made to be confused on purpose. And the confusion is, in and of itself, a tactic. Continuing. After the filing of Miss Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by 2 other deliberating jurors. The first, Juror D, stated that, quote, that the jury reached not guilty verdicts on count 1 and count 3, and that the disagreement was solely as to count 2 and its lesser offenses, end quote. Supplemental affidavit of Alan J. Jackson attached. She recounted that, quote, after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Reed on count 1 and 3? And they cite an attachment. Juror D unequivocally told counsel, quote, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3, because that's what happened, end quote. Juror E similarly stated, quote, that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges, end quote. Second supplemental affidavit of Alan J. Jackson. The Commonwealth filed a post-trial notice of disclosure informing the court that, quote, on Sunday, July 21st, 2024, Assistant District Attorney Adam Lally received an unsolicited voicemail on his office's phone line from an individual who identified theirself as a juror by full name and seat number, end quote. Commonwealth notice at 1, it's an attachment. The message stated, quote, it is true what has come out recently about the jury being unanimous on charges 1 and 3. ADA Lally received a subsequent message from the same individual stating he could, quote, confirm unanimous on charges 1 and 3 as not guilty, and as of last vote 9-3 guilty on the manslaughter charges, end quote. The Commonwealth additionally, quote, received emails from 3 individuals who identified themselves as jurors, end quote, and, quote, indicated they wished to speak anonymously, end quote. The Commonwealth declined to substantively respond to the voice messages or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters. Oh, the Commonwealth, ethically prohibited. Like that ever stopped them before. It's a charade, guys. It's a stage. It's a stage. The corruption is theater. You know, the ethically prohibited, it's just theater on behalf of the prosecution. They didn't want to hear those verdicts because that would mean the prosecution lost. The prosecution claims ethically prohibited when it's convenient for the prosecution to do so. Continuing. Re-prosecution on counts 1 and 3. Sorry, it's in Roman numeral 4. Re-prosecution on counts 1 and 3 will violate Miss Reed's double jeopardy rights. Letter A. Standard of review. Because Miss Reed is, quote, because Miss Reed is, quote, awaiting trial on state criminal charges, end quote, she, quote, is not in custody pursuant to the SJC's judgment, end quote, Gonzalez versus Justices of Munn. They're citing a case law. In parentheses, First Circuit 2004, vacated on other grounds and subsequently reinstated. Accordingly, this petition is brought under 28 U.S.C. subsection 2241, not subsection 2254. Section 2254's restrictions on the scope of habeas review therefore do not apply. Instead, the court, quote, must defer to the SJC's finding of fact, but must undertake plenary review of that court's resolution of issues of law, end quote. Provides a case law. In parentheses, Sixth Circuit 2014, quote, habeas petitions governed by subsection 2241 are not subject to the heightened standards contained in subsection 2254D, end quote. Quote, ordinarily a motion to dismiss on double jeopardy grounds rests on a pure question of law that the court reviews de novo, end quote. United States versus Candelario Santana. It's a 2020 case. Letter B, the constitutional protection against double jeopardy. The ancient right to a jury trial is no mere, quote, procedure formality, but rather a fundamental reservation of power to the American people, end quote. Erlinger versus United States. Quote, by requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions, end quote. Quote, prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury, end quote. Quote, after securing their independence and founding generations sought to ensure what happened before would not happen again. As John Adams put it, the founders saw representative government and trial by jury as the heart and lungs of liberty, end quote. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. See United States versus Martin. Quote, perhaps the most fundamental role in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution, end quote. Continuing, quote, the double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb, end quote. Bluford versus Arkansas. Quote, the underlying idea, one that is deeply ingrained in at least the Anglo-American system of jurisprudence, is that the state with all its resources and power should not be allowed to make repeated attempts to convict an individual for an alleged offense, end quote. Green versus United States. Quote, even if the first trial is not completed, a second prosecution may be grossly unfair It increases the financial and emotional burden on the accused, prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and may even enhance the risk that an innocent defendant may be convicted, end quote. Arizona versus Washington. Excellent citations. And pulling away from the memorandum, a lot of these citations were included in the original motion to dismiss via the Supreme Court. So Martin Weinberg, the defense team, they are relying on a lot of the same case law they cited previously, and all the case law is absolutely 1000% applicable, especially this one. Even if the first trial is not completed, a second prosecution may be grossly unfair because it increases the financial and emotional burden on the accused. It prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing, and that a second trial may enhance the risk of innocent Karen Reed being convicted, which is precisely what the prosecution wants. It's just not okay, guys. It's not okay. Continuing. Quote, at the heart of this policy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression, end quote. Quote, the clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty, end quote. Again, excellent citations. And again, if they seem familiar, it's because the defense team cited all this case law previously to no avail because the Supreme Court didn't give a damn. Continuing, letter C, reprosecution is barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. Quote, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial, end quote. The rule is rooted in, quote, the importance to the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate, end quote. United States versus Jorn provides another case law, Oregon versus Kennedy. Quote, the double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal, end quote. Thus, quote, after a mistrial has been declared without the defendant's request or consent, there's another footnote, number 5, the permissibility of retrial, quote, depends on whether there was a manifest necessity for the mistrial, end quote. United States versus Dinitz. So that's excellent case law, pulling away from the memorandum. I'm going to read that one again. Thus, quote, after a mistrial has been declared without the defendant's request or consent, the permissibility of retrial, quote, depends on whether there was a manifest necessity for the mistrial. It's an excellent citation because it argues that because Karen Reed, the first trial ended in a mistrial, and because Karen Reed did not consent to it and she was not provided an opportunity to object to it, the permissibility of Karen Reed's retrial is supposed to depend on whether there was manifest necessity for the mistrial in the first place. So it's like technically the state of Massachusetts isn't even supposed to be retrying Karen Reed on April 1st, 2025. They're not even supposed to be retrying Karen Reed if we consider this case law. Karen Reed was not permitted to consent to the mistrial, and there was no manifest necessity for the mistrial. Excellent citation, excellent case law. Continuing, the power to discharge a jury without a verdict, quote, ought to be used with the greatest caution under urgent circumstances and for very plain and obvious cases, end quote, United States versus Ramirez. And that's also excellent. The power to discharge a jury without a verdict ought to be used with the greatest caution. Right. And again, guys, Rule 27B is great caution. It's taking great caution because it's making sure that the judge overseeing the trial puts forth the extra effort to determine whether there were verdicts on each count when there are multiple counts against a defendant. And Judge Beverly Cannoni took zero caution. You know, like she's supposed to be taking the greatest caution. And she took zero caution. She took those jury notes at face value. Importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. Washington 434 U.S. Emphasis added, a burden that the state courts erroneously placed on the defendant. Excellent sentence. The heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the prosecution. But again, guys, notice how Judge Bev keeps putting the onus on the defense. Even the Supreme Court is putting the onus on the defense. It's so ass backwards in Massachusetts. Continuing, in assessing whether the prosecution satisfied its burden on this point, the First Circuit has stated it is, quote, useful to consider, end quote, the following three factors, quote, whether the trial court consulted with counsel, whether the court considered alternatives to a mistrial, and whether the court adequately reflected on the circumstances before making a decision, end quote. Right there, guys. Excellent. That's an excellent sentence. I'm going to read it again. In assessing whether the prosecution satisfied its burden on this point, the First Circuit has stated it is, quote, useful to consider, end quote, the following three factors. Number one, whether the trial court consulted with counsel. And we know Judge Bev did not. Before she declared a mistrial, she consulted with the attorneys for note 1 and 2, but after note 3, she didn't give a damn. So number 1 applies. Number 2, whether the court considered alternatives to a mistrial. And we all know that Judge Bev, on the record, as I stated in part 1, on the record, it is documented for all eternity that Judge Bev did not seek an alternative to that mistrial whatsoever. So number 2 applies. And number 3, whether the court adequately reflected on the circumstances before making a decision. Whether Judge Bev adequately reflected on the circumstances before she declared that mistrial. And she did not. And again, all she had to do was follow Rule 27B. That's all she had to do, you know? Zero caution. Continuing. Quote, embracing both consideration of alternatives and consultation with counsel is the amount of time devoted by the judge to the mistrial decision. A precipitate decision reflected by a rapid sequence of events culminating in a declaration of mistrial tends to indicate insufficient concern for the defendant's constitutional protection. Boom. Brady versus Samaha, 1981. Excellent citation. I don't even remember this one. This might be a new citation from Martin Weinberg or one of the defense attorneys. I'm going to read it again. A precipitate decision reflected by a rapid sequence of events culminating in a declaration of mistrial tends to indicate insufficient concern for the defendant's constitutional protection. You see, guys, Judge Bev made her declaration of the mistrial hasty. She was hasty. Rapid sequence. And insufficient concern for Karen Reed's rights. Excellent citation. I'm going to read this footnote. The SJC, it's number 5, the SJC did not find that Miss Reed or her counsel consented to the mistrial here. See opinion at 25 in 13. And for good reason, neither Miss Reed nor her counsel requested or expressly consented to a mistrial. While consent may in some circumstances be implied, quote, from a failure to object, end quote, any such finding requires, quote, at a bare minimum that the defendant had an adequate opportunity to register an effective objection, end quote. United States versus Toribio Lugo. For reasons discussed infra pages 16 to 18, no such opportunity was provided here. Excellent footnote. And, when a footnote is this important, I always wish they would just keep it in the main declarations, in the main body of the memorandum. But great footnote otherwise, that the SJC themselves agree with the defense that Karen Reed did not give her consent to the mistrial. So the Supreme Court agrees with the defense that Karen Reed never consented to the mistrial. Judge Beverly Cannoni, the Superior Court, agrees with the defense that the verdicts were true and accurate, but neither the Supreme Court nor the Superior Court agree that this should be dismissed. Yeah, but both the Supreme Court and the Superior Court, they both have proven to the world that they care more about the form when it's convenient for them to care about the form, right? Judge Bev especially. She cares about the form when it's convenient for her to care about it. Just like the prosecution, only cares about what's ethically prohibited when it's convenient for the prosecution to care about what's ethically prohibited. So we've reached page 15. So I guess I will try doing 7 pages at a time in this series. So I will upload part 3 soon. Might be tomorrow, might be another day. But as I've stated in previous videos, I I upload maybe 2, maybe 3 videos a week. So if you're new to this channel, welcome. But that's how I roll. I have made the Karen Reed case a huge part of my life, but it's not my whole life. You know, I'm also an activist. I also work in outreach in Boston. I'm part of another group who helps out the poor in Boston, and I also have a family. So the Karen Reed case is important to me, but I also have a lot of other things that are important to me. And so that's how often I upload on this channel. So for those of you who are cool with that and choose to stick around, thank you. Thank you for being here, and thank you for watching.